Hi. In this video, we're going to review some of Article 2's most basic concepts. We're going to talk about merchant rules, unconscionability, good faith, and supplemental general principles. In talking about the merchant rules, the most important point was that Article 2 applies to both merchants and non-merchants, but it contains some provisions applicable only to merchants. For example, the statute of frauds in Section 2201, paragraph 1 applies to everyone. But the confirmation exception in Section 2201(2) applies only to contracts between two merchants. Why is that? Well, Section 2201(2) expressly says that it's applicable only to two merchants. A party can be a merchant in one of four ways. One is by dealing in goods of the kind involved in the transaction. A second is by having knowledge or skill as to the goods involved in the transaction, but this is only for the purpose of goods provisions, like Section 2314 on the implied warranty of merchantability. You can find a list of goods merchant provisions in comment number 2 to Section 2104. The third way is by having knowledge or skill as to practices involved in the transaction, but again, this is only for practices provisions like Section 2201(2), the statute of frauds confirmation exception, or Section 2205 on firm offers. And again, you can find a list of practices provisions in Section 2104, comment number 2. The fourth way is by hiring an agent who has knowledge or skill necessary to qualify as a merchant. The third thing we learned is that a person can be a merchant for the purpose of some UCC provisions or some transactions, but not others. So, for example, a bicycle shop owner might be a merchant when selling bicycles, but would not be a merchant and would not make implied warranty of merchantability when selling an old used cash register. We saw an example of the pattern of argumentation that merchant rules give rise to in the Loeb & Company v. Schreiner case. The plaintiff's claim was that the defendant breached a contract to sell goods, to sell his crops. The defendant's response was, "My promise is not enforceable because it's not in writing as required by the statute of frauds." The plaintiff's reply was, well, the statute of frauds is satisfied because the defendant, the farmer, failed to respond within 10 days to a confirmation that I sent to him. And the defendant's reply was, well, the confirmation exception does not apply because I'm not a merchant. I'm a farmer and farmers aren't merchants. That's the conclusion Loeb & Company v. Schreiner reached based on its reading of the definition of 2104. Other courts disagree about the specific conclusion that farmers are not merchants, but the pattern of argumentation would remain the same in any case. The next topic that we talked about was unconscionability. Here we saw three basic rules or principles. The first is that a court may refuse to enforce a contract or a term of a contract that it finds unconscionable. Second is that courts monitor contracts for oppression, sometimes called substantive unconscionability, which might be produced by remedy meddling or excessive prices or something like that. And they also monitor them for unfair surprise, which is sometimes called procedural unconscionability, which might result from hidden contract terms or contracts offering no meaningful choice. The third rule or principle is that courts rarely invalidate contract provisions as unconscionable, especially in contracts between merchants. We saw an example of a pattern of argumentation involving unconscionability in the Barco Auto Leasing v. PSI Cosmetics case, the first case that we read this semester. In that case, the plaintiff claimed that the defendant breached an implied warranty of merchantability. The defense was, well, the implied warranty of merchantability was disclaimed, and the reply was that the attempted disclaimer was unconscionable, it was oppressive, and therefore not enforceable. Another topic that we talked about was good faith. Here we saw that some UCC provisions expressly require good faith. For example, the buyer under a requirements contract must specify the quantity of goods required in good faith. The buyer can't simply make up a number, it has to be the actual requirements. Second, we saw that all UCC contracts also contain an implied duty of good faith in their performance and enforcement, though not necessarily, or though in particular not in their formation. The third principle was that the general definition of good faith requires only honesty in fact, where by contrast the merchant definition of good faith requires not only honesty in fact, but also the observance of reasonable commercial standards of fair dealing in the trade. The existence of commercial standards of fair dealing in the trade, though, must be proved. They simply won't be assumed to exist by the court. Pattern of argumentation might be as follows. The plaintiff might claim that the defendant breached the implied duty of good faith when the defendant did X, some activity, some action. The defendant's defense would be, well, there was no breach of the implied duty of good faith because there was no dishonesty. I didn't do anything that was dishonest. And if I'm a merchant, well, the plaintiff has not shown that standards of fair dealing in the trade prohibit X, whatever action it is that I did that is said to be lacking in good faith. We saw an example of that in the Zapata v. Dairy Mart case, where Zapata alleged that Dairy Mart had terminated the contract in bad faith. Dairy Mart said we didn't act dishonestly, and Zapata hasn't proved the existence of any commercial standards of fair dealing in the trade. A final point that we talked about, and perhaps one of the most important points, is the idea of supplemental general principles. The basic idea is that unless displaced by particular provisions of the UCC, otherwise applicable principles of law and equity supplement the UCC's provisions. In other words, the UCC just simply sits on top of the common law and other statutes, modifying them to some extent, but otherwise leaving them intact and leaving them applicable. Through supplemental general principles, plaintiffs can assert claims not based on the UCC, and defendants can assert defenses that are not based in the UCC. So, for example, a plaintiff might claim, in performing our contract for the sale of goods, D's conduct gave me a claim under a state statute applicable as a supplemental general principle of law. We saw an example of that in the Zapata v. Dairy Mart case, where Zapata claimed that he had a right under a Massachusetts statute providing a cause of action for unfair trade practices. Although the court was applying Article 2 of the UCC, it saw no reason not to also consider other types of claims that the plaintiff might have. Similarly, defenses might be added to the UCC by virtue of supplemental general principles. For example, the plaintiff might claim that the defendant promised to buy or sell goods and the defendant didn't do it, and the defendant's defense would be, well, the promise is not enforceable because it was induced by a statement constituting a misrepresentation under common law rules, which are applicable as supplemental general principles. Although the UCC doesn't say anything about misrepresentation, the common law does, and because the UCC doesn't say anything about the subject, the common law rules are not displaced and they're still applicable. Those are some of the rules that we've seen concerning basic